So good morning, everyone. I may start. I've been given signs to start, so I think it's time for us to start again. We know that you come at a time where you are a bit tired. The good news is that we are between a break and a lunch, so keep with us, and lunch is coming after that panel. So it's my pleasure really to chair this panel and to welcome three discussants on this panel. I would like to thank them for agreeing to be discussant on our panel. So we have really lots of variety in our panel. We have Dirk Vanheule, who is a full professor of constitutional and administrative law at the Faculty of Law at the University of Antwerp. And sorry for the pronunciation. I know every time I'm trying, I'm making mistake. His teaching and research interests include constitutional law and migration and asylum law. And I know also that you do lots of comparative studies on migration law. So welcome and thank you for being a discussant on the panel. We also have François Bienfait, who is a lawyer by training, but who is also currently the director of ADDE, which is called Association pour le droit des étrangers in Brussels, a local NGO dealing with foreigners' rights, who does training and consultancy for migrants and others in need of information. In between, François had been a justice and home affairs expert for a Belgian deputy prime minister, and he was also selected to become the Belgian Deputy Commissioner for Refugees and Stateless Persons. He was also appointed by ESO, the European Asylum Support Office, based in Malta, to help with training and quality and expertise. We will end with a discussion by Rob de Lobel, who is actually with the IOM, the International Organization for Migration, who joined IOM in 2018. He's heading the LMI unit, which is the Labor, Migration and Social Inclusion of the Country Office for Belgium and Luxembourg. And since 2018, Rob initiated several labor migration schemes to Europe, some relating to permanent migration, while others having a more temporary nature. So, of course, this is talking to us as a Canadian researchers, but surely not so much in the European context. I'm sure you will talk about that. Yes, let's start. We just wanted maybe to start by explaining why. Why do we do a presentation on vulnerability and temporary migration in the Canadian context? Because we feel it is important, and this is, I think, what we heard in the last few days, to move away a bit from a discussion, a very important discussion that is on refugees and asylum seekers, who clearly are vulnerable, but also by highlighting other groups of migrants that often fall through the cracks, in fact, and yet can be subject to similar or unique experiences of vulnerability. And as a reminder that it was also, in fact, a key impetus for the Global Compact of Migration, to recognize the need to better protect migrants in vulnerable situations who are not refugees. Also because the focus on temporary migration is really timely and relevant in the Canadian context. This is due to Canada's changing landscape. So Canada has been known all over the world for its permanent immigration scheme. So we had for decades and decades permanent residents selected abroad and coming with a series of rights and slowly transitioning to citizenship. This is still happening, but really not in the same dimension as it was before. What we see is a huge increase in temporary migration. And just to give you an idea, in fact, since the mid-2000s, Canada, in fact, has admitted more temporary labor migrants than permanent economic immigrants each year. And we see an increasing proportion of new permanent residents who are people who have already been working in the country on temporary permits. So there is really something happening in terms of coming as temporary and moving, if you can, because of course, this is not always an easy process, moving to permanent residence. We also see that there is a plethora. So, I mean, it was interesting, linked to the last panel, you know. Clearly in Canada, we have an assumed temporary migration scheme, and we have an assumed temporary labor migration scheme. So we have a plethora of different temporary migrations programs that have been implemented, each with their own eligibility criteria, restrictions, and entitlement. And this is really creating a complex labyrinth of programs and multi-step processes. So just to give you an example, a small example, we have in Canada two principal streams for temporary labor migration. The first one is the Temporary Foreign Worker Program, which we commonly call the TFWP, and the other one is the IMP, the International Mobility Program. Within the IMP, solely the International Mobility Program, there are approximately 70 admission category, 70s, each with their own specifications, their own conditions and requirements. So you can imagine that this is, you know, the landscape is complex. And so within this context, also what we see is Canada moving increasingly towards what we call a two-step immigration system, where a person is expected to spend a certain amount of time in Canada with temporary status, accumulated Canadian employment experience or education, and before qualifying for permanent residency. So, interestingly, in the Canadian context, the vulnerability of temporary migrants is really well illustrated. While for a long time, the focus was mainly on the vulnerability of workers admitted into Canada on an employer-specific work permit. So we have lots of studies and maybe something to discuss, because I know that there is really a willingness to expand the labor migration schemes in Europe. We have research showing how problematic it can be to be tied to a single employer. We really have lots of research on that. So this research exists, but what we also see is growing, emerging research on international students, on skilled workers as well in a certain way, but who are also tied to an employer, on sponsored spouses who experience similar challenges in a number of areas, including at the workplace or in accessing healthcare, for example. Research is also showing that transition to permanent residence, which is currently an expectation, an increasing expectation. So transition from within Canada is much more complex as what we would expect, that it is riddled with barriers and attainable only, in fact, for those who can meet the stringent eligibility criteria. Finally, what is increasingly documented in empirical research is the complex trajectories of temporary migrants. And I know, for having talked with my European colleagues, that you are not experiencing maybe the same, kinds of situations on the ground. But what we see is many temporary migrants who experience changes in status once admitted in Canada. This change can be from one temporary status to the other, from international student to temporary worker, from temporary worker on an open work permit to temporary worker on a closed work permit, from visitor to student, from temporary worker to sponsored individual, from temporary worker to international student to refugee claimants. So also from having a legal status to losing one, to trying to recover it. So really there are a growing number of studies highlighting the side effects, in fact, of increasing complexity in the Canadian context. And interestingly, the Canadian government has increasingly recognized that. It has increasingly recognized the vulnerabilities associated with temporary migration status. One result of this has been the creation of various pathways to temporary or permanent protection for temporary migrants. The most recent initiative is really the open work permit for vulnerable workers. So you have the title, you have the word vulnerable in the title, which was implemented in 2019 and which authorizes immigration officers to issue open work permit to migrants who are on a closed work permit, i.e. an employer-specific work permit, and who are experiencing abuse at the workplace. We also have the temporary resident permit, the TRP, that is granted to temporary migrants recognized as victims of human trafficking or of domestic violence. We also have temporary migrants with uncertain legal status in Canada who are ineligible to apply for permanent residence through other streams and who may obtain a permanent residence with pathway to citizenship after a successful humanitarian and compassionate application has been made. It is also worth noting that the Canadian government is currently developing an initiative to regularize the status of what is estimated to be I would say between 250,000 and 500,000 migrants who are currently living without legal status in Canada. We don't have any official data. So not surprisingly, our Canadian research covers a broad range of protection procedures, including refugee protection, of course, but also permanent and temporary protection mechanisms, such as humanitarian and compassionate claims, the open work permit for vulnerable worker, the TRP, the temporary resident permit. So really throughout the VULNER project, the Canadian team sought to answer 3 questions. The first one, which you can see on the slide, and which is very common to every single team, was addressed during the first phase of the project, where we focused our research activities on compiling and analyzing Canadian government documents and court cases pertaining to the vulnerability of migrants. Question 2 and 3 were actually addressed during the second phase of the project, where we conducted semi-structured interviews with 110 participants, including civil servants from the federal government, on-the-ground practitioners, mainly lawyers and NGO representatives, and migrants. And several Canadian provinces were examined. We include in our study Ontario, Quebec, Alberta, Manitoba and Saskatchewan. And it was important for us to do that because there are important variations between provinces. So let's move now to our key findings. And Anna, you are next.
So we've had to narrow down the key findings for this presentation. And this is this one? Yes. Yeah. So the first, these are some of the key findings that we identified with regards to being identified as vulnerable. And we're starting with the substantive impacts that an identification of vulnerability can have on the outcomes of the cases. So as a brief preamble, I want to note that the findings of this section were primarily from our second research report and the interviews that we conducted for it. So civil servants were asked how vulnerability impacts both the procedures and the outcomes of the decision-making process, and their answers varied significantly depending on which of these different migratory schemes they were working in. There were 3 streams where we saw vulnerability playing a outsized role, or a more important role. The first is the case of applications on humanitarian and compassionate grounds, which Delphine just mentioned. So these are a measure of last resort that are supposed to address cases where people have fallen through the cracks of the other migration schemes. And decision makers in humanitarian compassionate claims are able to adopt a very comprehensive approach to the cases before them. So they are able to consider a wide range of factors. And as a result, one of those factors is vulnerability. And so as one of our participants noted, the way that the provisions of the Immigration and Refugee Protection Act pertaining to humanitarian and compassionate grounds have been interpreted have really changed over the years. And there's now an acknowledgement of vulnerability of all kinds in that interpretation. The second area was with respect to the open work permits, which was just mentioned. Now, as we said, these are open work permits for vulnerable workers, so the idea that vulnerability is a key factor is sort of in the name. It goes without saying. So these are work permits for people who have been subject to abuse or exploitation, and by definition, their vulnerability is important. And increasingly, or interestingly, the civil servants who we interviewed who worked in this program were the ones that had the most nuanced understanding of vulnerability, and particularly had the best understanding of their own role and the role of the systemic factors in creating vulnerability. In other instances, many of the decision makers saw vulnerability as something that was brought to them, as opposed to something that was potentially created by the systems that migrants were traveling through. Last but not least, the third category of application where vulnerability played a more substantive role was with respect to temporary resident permits granted to victims of human trafficking and domestic violence. And again, the reason for that is fairly obvious. Now, in all of these cases, vulnerability can positively impact the decision. In other words, it can result in an award of protection. But in these last two cases, the degree of vulnerability could also impact the type of, or the length of temporary status sought. So with the humanitarian and compassionate considerations, it's a permanent status being sought, but the other two is still a temporary visa. And individuals who were more vulnerable were likely to receive a longer term for their visa. So for instance, somebody who was a minor or someone who had been subject to sexual abuse. Now, in looking at how these cases are assessed, however, we arrive at our second finding, which pertains to the challenges posed by the wide margin of discretion that decision makers have in assessing applications and prioritizing one vulnerability factor over another. As we are all aware, it's rather trite to say that discretion is a double-edged sword. It allows for flexibility, which is essential, and particularly in the assessment of complex claims, but it also results in a lack of predictability. And the breadth of discretion that's afforded decision makers in Canada was seen by both migrants and by practitioners as being problematic, and contributing significantly to the vulnerability of many of the migrants. And this was reinforced by our findings that immigration officers themselves often have very different understandings of what constitutes vulnerability and who a vulnerable migrant is. Now, again, the degree of discretion does vary depending on the program line. So, for instance, in humanitarian and compassionate claims, there is a very broad range of discretion. And this is in part because, as the Supreme Court of Canada has noted, the objective of these applications is to mitigate the rigidity of the law in an appropriate case and to provide recourse to migrants who would not qualify for any other migration class. So this is very much built into the program, this broad discretion. So as a result, discretion is fundamental to the ability of the agency claims to function as a safety net. Unfortunately, this results in uncertainty and unpredictability. As one interviewee told us, as a decision maker, I struggle a lot with that because I could understand that another decision maker could take a different decision on a specific set of factors, but I could not understand why me, with the same view of things, could one day approve, one day refuse a similar case. And other interviewees made similar observations, with one noting, for instance, that people make very different decisions after they have children. Now, our interviews thus raised some substantial concerns about the scope of discretion and how it is exercised in these cases. In all cases, vulnerability is regarded as one factor among many. It may be a substantive factor in the outcome, but it isn't necessarily, even when it is considered. And the weight attributed to vulnerability, to any particular vulnerability factor, will vary greatly within the program line and also just from decision maker to decision maker. So unlike in claims before the Immigration and Refugee Board of Canada, where there is a clear, if imperfect, set of guidelines outlining how different factors of vulnerability are to be considered. For instance, we have our SOGI guidelines, so on sexual orientation and gender identity expression, which have been held up as kind of a model for other institutions or other countries as well. there is no such guidelines in the assessment of claims by immigration officers. Now, some interviewees noted that they do occasionally refer to the IRB guidelines, but those aren't legally binding. And in fact, many of our interviewees, even the civil servants, suggested that that was something that they would like to have more concrete guidance on how to apply these factors in order to create a bit more predictability. Another factor we came across was barriers to applications. And so this next finding of note relates to barriers that temporary migrants face in applying either for temporary status or for permanent status. And these barriers prevent migrants from either making claims for protection or at very least making effective claims. And thus, they result in a continuation of or exacerbation of precarity. So some of the barriers that interviewees drew our attention to were unsurprising, and probably you all saw similar findings. So for instance, the lack of effective legal assistance and language barriers. Now, by lack of effective legal assistance, we are referring both to migrants who were unrepresented and to those who were underrepresented or represented by ineffective counsel. Access to legal aid in Canada varies from province to province, but certain groups, such as migrant workers, are largely excluded from being able to access legal aid, except in those few cases where the province has stepped in to provide a stopgap measure, but that isn't across the whole country. And so temporary migrant workers are often left to navigate those very complex pathways that Delphine mentioned, without representation. And without legal representation, the likelihood of a successful claim is dramatically reduced. But more than that, given the multiple different migration streams in Canada, without assistance, migrants may not even know what claims they could potentially have, where they could potentially seek protection. So they may not even make a claim to begin with. And so in the absence of government legal aid, much of the burden of this work falls upon civil society members that are both underfunded and understaffed, because in many instances the government does not provide funding to NGOs to provide services to undocumented migrants or to temporary migrant workers. Similarly, language barriers often mean that migrants lack knowledge about Canadian laws and policies and institutions. And this came up frequently with respect to migrant workers, as without access to proper information, migrant workers remain unaware of their rights and tend to receive misinformation from unreliable sources. There's a lot of gossip sort of going around, and that's how information is passed from one place to another. And several of our interviewees also noted that many of the temporary migrants have very low literacy rates in their own language, much less in English or in French in Canada. And so accessing relevant information, much less filing claims for protection, is extremely difficult. In our interviews, many migrants expressed frustration at the lack of and the expensive nature of acquiring reliable legal representation, without which it is not possible to access protection effectively. Now, another barrier that arises in the context of applications for protection is the challenge posed by having to prove one's vulnerability, or in some cases, to prove abuse or exploitation. In this regard, several practitioners that we interviewed criticized immigration officers for their disproportionate focus on physical threats and their inability to consider that abuse can manifest itself in many different ways and does not always appear in a physical form. So as one community worker explained, vulnerability as a result of forced labor exploitation is seen, and I quote, in this very mainstream way of being locked up and tied to a room. Interviewees also highlighted a gender imbalance here, where claims of abuse made by male temporary workers were not taken as seriously as those that were made by women. They were not considered to be as vulnerable as their female counterparts. Participants also highlighted the psychological dimensions of exploitation, coercion, and intimidation, and that are often ignored or disregarded by immigration officers. And this narrow understanding of abuse that many officers had may undermine the ability of some migrants to have their vulnerability recognized and to successfully claim protection. And our next finding is the vulnerability of migrants is being exacerbated in situations where there's a lack of proper support and assistance. And this relates in part to the appointment of designated representatives. So under the Canadian Immigration and Refugee Protection Act, which is our main piece of legislation, a designated representative must be appointed by the Immigration and Refugee Board to assist unaccompanied minors or adults who are unable to appreciate the nature of the proceedings due to mental illness or cognitive issues. The designated representative is appointed to ensure that the interests of the person in question are, the person who's appearing before the Immigration and Refugee Board are being properly represented. Unfortunately, there's no such provision for the appointment of a designated representative outside of the Immigration and Refugee Board hearings. And the Immigration and Refugee Board hearings in this case that we're talking about are primarily asylums, though not only. There are also no designated representatives, so before the IRCC, so the Immigration, Refugee, and Citizenship Canada, it keeps changing its name, or before the Canada Border Services Agency. And they're the ones who are doing most of the types of hearings we're talking about. So according to the lawyers that we interviewed for this project, this is really problematic because, in particularly, it is the most vulnerable migrants who don't have the capacity to understand the decisions being made and who may face irremediable consequences, including deportation, simply because once you start the immigration proceedings, they continue with their own momentum. And without having a designated representative or a lawyer to intervene and to stop what is going on, people simply get swept away with that procedure. So since the role of designated representatives is to ensure that vulnerable persons understand the process and make decisions that are in their best interests, they should be available in any immigration proceeding, not just in asylum cases or those cases before the Immigration and Refugee Board.
Yeah. So,
Sorry. No, back one.
Back one?
Back one. That one.
Okay. So I'm mindful of time, so I think I will be very quick on that one. But of course, the fact of not having legal aid means that you are using immigration, that you are using people who actually take a lot of money from you and basically tell you some things that are completely false. And what we realized is that and it's not really, there is not much regulation. There is a lack of repercussions also for those people who are providing advice to migrants who are completely false and who are taking a lot of money from them. So more should be done on that front. And also we talked about that a lot. We are, as I said yesterday, we are also faced with delays in the Canadian context. And they are really exacerbating vulnerability in many ways. The Canadian government is now moving for almost everything to online applications for permanent residence. We heard from NGOs on the ground and from lawyers that this is really a complete nightmare because this is not working well. This is adding much more work on everyone's actually, and sometimes some of the blanks that you cannot fill in because there is not a good fit for the proper answer, and also as we discussed yesterday, the importance in fact that was raised by the stakeholders of just providing information to the migrants, where are they in the process? Because the delays are one thing, but not knowing what is happening with your application is another one. And it is very difficult to get answers as to, where is in your application in the system. And we had wonderful suggestions by our community partners that I think would not cost much to the Canadian government, and we hope, they will listen to them. them, for sure. Finally, also, something really very brief, but there is, you know, in the Canadian context, it's really difficult when you have a negative decision to actually change that decision. In fact, the appeal mechanism is only available for failed refugee claimants, so in the field of refugee law. It is not available in the field of immigration law. So this is, you have to go through judicial review, but what you have to do is seek judicial review first. So you have to get an authorization from the federal court to actually judicially review the decision. And it's very rare, actually, that you can get authorization from the federal court, and even when you get it, it's even more rare to actually get judicial review of your decision. And what judicial review means is that your decision can be sent back to the same or a different immigration officer who will make again the same type of decision. So, I mean, there are really issues also with recourses in the field of immigration. And you know, there should be some changes, we feel, in this area. Last but not least, I think Anna talked about that, so I will be extremely brief, but what we saw on the ground indeed, and what we know for a long time, is that legal aid is missing, but also settlement services. You're going to tell me they are temporary migrants, so they don't need to settle, they don't need to access settlement services. Well, in the Canadian context, it's complicated since many of them, in fact, are transitioning to PR. And also because what we keep hearing from the migrants who went through very difficult and complicated stages before getting PR, after years and years of struggles, they say, now I get access to everything. And as I was struggling, you know, this is what I needed before. So, you know, there is really a push to really make sure that if indeed they are transitioning to PR, and not all of them are to permanent residence, let's make their PR a smoother process, right? Finally, as for the key recommendations, go ahead, Anna.
Oh, you made that go to sleep.
Oh, so you can see, it's a face.
Technology.
Yeah, it's a face ID. Yeah, okay. So, can maybe. Yeah.
So we just, our recommendations are set out well in the document, and we've divided them here into the shorter term versus the longer term. So just to highlight a couple of them. One key recommendation, which has been echoed by many of the participants in our interview, was the need to move away from employer-tied visas. So this is recognized by both the government side and to some extent, and certainly by the practitioners and the migrants themselves, and also to increase the duration of temporary visas so as to promote stability in the system and to prevent migrants from falling out of status. The decision-making system itself requires some improvement to better accommodate vulnerable migrants, and this we've mentioned in terms of decreasing backlogs, so by hiring more decision makers, providing more complete information, extending the mandate of designated representatives to the most vulnerable migrants, and generally strengthening oversight and appeal mechanisms. And finally, with respect to the non-governmental sector, our research has, again, reaffirmed the need for further investment in both resettlement and services to non-refugee migrants, and of course in legal aid to better facilitate or assist migrants so that they are not left to navigate these really complex systems on their own.
And so finally, before I give the floor to the discussant, several of actually the recommendations we make can be found in Objective 7 of the Global Compact. So we feel that actually if they are in the Global Compact, maybe, you know, those measures are also needed in other countries, like, you know, access to legal aid, efficient legal aid, and many other measures like, you know, collaboration with key stakeholders, etc., etc. So, you know, this is a commitment from states to improve the situation. So we hope it will indeed be improved. Thank you very much for your attention. And I am now moving to Professor Vanheule for our first discussion, and then to François after. Yeah, as you wish.
Thank you very much for the organizers for inviting me, and thank you very much also Delphine and Anna for your interesting approach on what I would call a type of system-induced vulnerability, where the immigration legal framework and policy inherently create or contribute to situations of vulnerability. I would like to make 4 observations. The first one on time continuity and immigration, the second one on compartmentalization, a third one on the nature of public administration, and a last one on the concept of vulnerability used throughout your paper, but also throughout this conference. Your observations relate to the temporal aspects of immigration policy and rules, and where duration is indeed a very complex issue. It is interesting to observe that Canadian immigration policy has partially shifted from permanent settlement towards temporary labor migration schemes, and in this sense, it resembles the approach taken in many European countries, where the starting point of immigration is often limited in time and made very conditional on having a particular job offer or a certain qualification. The underlying idea of such an approach is that return after the temporary stay is the outcome of the whole process. And only in exceptional cases, after 5 years perhaps of permanent residence, stronger status such as long-term residence can be obtained. But quite often there are administrative and legislative measures that inhibit that or that render that very difficult to reach that permanent status. And I hear the same thing is occurring also in Canada. And under such an approach, temporary migration is seen as a discontinuity in the life of the migrant. And the life of the migrant is predominantly perceived as being lived in the country of origin. And this is, of course, in contrast with the realities of the continuity of life. People's lives change all the time, and while temporary stay may initially be the objective for migration or for mobility, that may change. People fall in love, people find other jobs, and just as temporary residents want to remain for a longer period, you also have permanent residents that decide to return back or to move to another country. And yet, if you think of temporary migration as a discontinuity and that people will return eventually to their country of origin, I wonder to what extent that idea also creates the idea in the mind of policymakers that migrants always have a fallback position, that even in situations of vulnerability, there is a fallback. Well, you can always return to your country of origin, and hence the problem of vulnerability is going to be solved. And it may be that this approach is also responsible to a certain obliviousness at the policy level about situations of vulnerability that you have identified in your paper. So the acknowledgement and the acceptance of continuity in persons' lives and the needs that hic et nunc exist and change constantly without necessarily there always being a return plan may help in raising awareness about situations of vulnerability. And perhaps this may also help in the implementation of a vulnerability framework that you are referring to also in your key recommendations that you have made in the paper. I would like to come to a second point. The existed limited duration approach leads also to a certain compartmentalization of a migration trajectory that does, once again, not correspond with the realities of life. If we look at European legislation, you see that it's already being compartmentalized in access, short stay, a bit longer stay, temporary conditional stay, permanent stay, and the temporary stay is very conditional. In time, also connected to certain purposes, either you come to study, you're going to come to work, or for other reasons. And in such an approach, of course, changing compartments is not obvious, whereas the complexity of life and the reality of life ignores these lines. It's not if you're living your life that you're thinking of your life, I'm sitting in one compartment of a train and now I'm going to move to another compartment. You're still in the same train that you are sitting in. And when gaps fall because changing compartments is not possible under immigration law and immigration rules, you eventually will end up in situations of vulnerability. Access to rights and services are going to fall